Mark J. Stern.
Thank you so much. I will be switching over to the seated version of speaking now. And it's my pleasure to be here today and to be with all of these wonderful folks fighting for democracy, and to also be with a fantastic panel who I'm going to invite up to the stage now. If my panelists could come join me, thank you so much. You can all applaud for them after they've seated and after I've introduced them. I like to build it up so everyone gets really excited. So starting on the right, we have Brandon Hasbrook, who is a professor at Washington and Lee University School of Law. Then we have Kermit Roosevelt III, who is a law professor at University of Pennsylvania, who also served on the Presidential Commission on the Supreme Court. And last but certainly not least, Caroline Fredrickson is a senior fellow at the Brennan Center and a visiting professor at Georgetown University Law Center, great school, who served on the Presidential Commission on the Supreme Court of the United States. Welcome, panelists. Some brilliant minds here with me. I really struggled to figure out where to start, but I think I'm going to start with Kermit, because Kermit, you wrote a very interesting piece after your service on the Supreme Court Commission. And what you wrote was, I went into the process thinking that the system was working, but that improvements were possible. I came out scared. Court expansion may be the only thing that will save our democracy for the next generation. So I guess I just want to hear, what was that evolution like for you, and how did you end up going from kind of cautious incrementalist to declaring your support for expanding 4 seats to the court?
Thanks.
It is on.
It is on? Okay. Well, so it's just a situation, and this has happened to me with a bunch of different issues, where the more you learn, the worse everything looks. And then once you start to put it all together, you're like, wow, these are not isolated bad things happening. There's a pattern, and it's all part of a project. And if we don't stop it, basically the way that I saw it, we're going to have a minority takeover of our government. And that's sort of the connecting thread that I see between all of these things, because sort of to our misfortune, it's sort of an accident. There are structural features of the Constitution that allow a minority to control every branch of the federal government. So with the presidency, it's the Electoral College. With the Senate, it's equal representation for each state. With the House, it's gerrymanders. And it's possible for a minority to take over. And that's, what we saw happen in the recent past, and that's what people are building towards now, I think. And we've got a Supreme Court where a majority of the justices were nominated by minoritarian representing presidents. And this movement, we sort of took back the presidency, we took back Congress. We can't take back the Supreme Court without expanding it. But this movement is going to try again. And I really think that in order to stop that and in order to protect democracy, we need to get the court back.
Thank you. I have some points I want to return to, but first I want to turn to Caroline, because you served as a fellow commissioner in those endless Zoom meetings. And you wrote after your service, initially skeptical about the idea of enlarging the court. By the time our work was over, I had come to support court expansion. While I still back term limits for justices as well, that reform will not have an impact soon enough to mitigate constitutional tyranny by the court. So let's hear your come to Jesus story. What happened here?
Well, I think I'd have to echo a lot of what my fellow commissioner had to say, which is, we went in and it was a very serious-minded, enterprise, and a lot of serious people who looked at the variety of reforms that had been suggested. And I would just say, I was talking to my law students about this, and they came up with a whole bunch of other ideas that, and I said, well, you got to get them out there, because we didn't consider them because they haven't been put out there by, in the serious way that is required. But so we had all these different issues that we were looking at. Amongst them were considering whether or not, we actually addressed the power of the court directly through changing its jurisdiction, or having some kind of a congressional override, or perhaps a 2/3 vote requirement for the Supreme Court on constitutional law decisions. And we looked at ethics and recusal rules. And but when it really comes down to it, the only thing that is really within our grasp, if you really came to this project because of deep concern about the role that the court has played in our democracy and the really noxious effects of the Supreme Court's rulings, the only thing that we really have in front of us is to change the size of the court. That is because the other issues are all raised a lot of constitutional questions about how we could go about doing those things, changing the court's jurisdiction. Well, who gets the last word on that? I guess it's probably the court, so it becomes a really difficult process to try and say, well, I don't think the court should rule on election cases. Say, for example, we're really worried. Now, the Voting Rights Act is hanging by a thread, the last thread that is left of that statute, and is likely to be chopped off by this court. What do we do under those circumstances where the court has taken so much power to itself? Well, we struggled with these issues, and I also came to it. I thought I'd long thought that term limits was just a good idea. Had vague thoughts about jurisdiction reform, but after sort of examining all of the kind of complications of those other areas, and I still support term limits. I think it can still be done. There's still an argument that it doesn't have to be done through a constitutional amendment. But changing the size of the court is the most direct and the only one that speaks to the democratic imperative that we have in front of us when you do have a court that has blessed radical partisan gerrymandering, allowed for a flood of dark money into politics, has undermined voting rights to such an extent, and unleashed basically an extreme right-wing religious domination of our court system to the detriment of all of our most fundamental rights. So I came into it as rather a skeptic, but obviously I'm passionate about it.
Love the passion. I think your discussion of the Voting Rights Act is going to tee up a very important conversation for us. And I think turning now to Brandon will be helpful there. So you recently wrote an article that was headlined, "Pack the Court with Color-Conscious Justices." And you said, advocates of court expansion focus primarily on retaliatory politics rather than redressing the court's chronic anti-Blackness. We cannot pretend that court packing alone will lead to a healthy justice system that values Black lives. So I'm curious, not just what you meant by that, which I think is pretty clear, but what motivated you to write that in the midst of this broader conversation about court expansion? What was your goal there?
Yeah, sure. So that article dropped a few years ago. So I've always been a proponent of court expansion. And Bakari Sellers did this. So allow me also to quote Jay-Z, allow me to reintroduce myself. I am an abolitionist and a movement law professor. And I mentioned that for a few reasons. And first, the Supreme Court created the ecosystem of blue on Black violence, all right, through their decision making. They had a choice to interpret the Fourth Amendment one way, and they decided to interpret it in an anti-Black way, okay? Now, what does that mean? It's not lost upon me in the summer of 2020 of George Floyd, of Breonna Taylor, the tools, the superpowers indeed of policing was given to police by the Supreme Court, but it's just not that. It's voting rights. It's Shelby County taking power away from Black people, where now our votes can be suppressed and our bodies gerrymandered, okay? So court expansion also is necessary to preserve democracy. Conservatives have used a combination of obstruction and taking advantage of the Constitution's anti-democratic allocation of power to entrench the power of a political minority in the Supreme Court. Without court expansion, that's likely to last a generation. Think about that for a minute. But it's not just the Supreme Court that needs to be expanded. The lower courts also need to be expanded. And I mention this in particular because the Supreme Court decides roughly 60 to 63 cases a year. And I know it's terrifying for people in this room come April and May when those decisions drop. And we're going to talk about it in a little bit. It's going to get worse, okay? But the appellate courts, the lower courts, they decide almost 50,000 cases a year. So I propose in an article that at a minimum, in terms of appellate courts in expansion, we need to expand that court for at least 63 appellate judges. Not only 63 appellate judges, and that's based on population growth since the last time the court was expanded, but it also needs to be 63 women, in particular, 55 women of color, to get to racial and gender parity on the court. You're like, well, why? Well, the courts are white, and I'm talking like, I don't know, put raisins in your potato salad white. That is the courts we're working with. So now, and make no mistake, you heard earlier that, well, what's gonna happen if we expand the courts? Will Republicans expand the courts after? That's already part of their playbook. Listen to this really quickly. Prominent conservative law professor Stephen Calabrese, he's a founder and a co-chairman of, with Leo Leonard, of the Federalist Society. He's already proposed to expand the lower courts. And the reason why, Chris, I think you appreciate this, is because President Obama's moderate judicial legacy. So imagine what they are planning to do when President Biden's historical body of work to date is recorded. So this is what we're up against. And for people in this room, and I'm looking out and I see many Black people, this is about us, our ability to live, our ability to walk down the streets, our ability to do anything without thinking us or our children's lives are going to be at stake and could be lost.
Thank you. Yeah. So I'd definitely like to hear your responses. One thing I'm curious about is whether you feel like a perspective like that was included in the commission, whether you heard that particular perspective when you were debating these various reforms and ideas.
I'd first like to... Sorry. Forgot. I'm loud, so I forget about my microphone. I just want to first speak to this idea of expanding the lower courts and to say I heartily endorse that. I think it's interesting. I don't think Steve Calabrese has been anywhere talking about expanding the courts in the last couple of years. That was at the beginning of the Trump administration. He doesn't necessarily think that it's true now, right? Because different president. But I would say that it's really important to remember, I think President Biden has done a really pretty good job of proposing much more diverse nominees than has been the case in the past, including, importantly, thank you, Demand Justice. You've worked on this a lot, and some of the other groups that are in here, but a diverse background in terms of practice areas, which is also super important to have, public defenders and have trial lawyers and have people who do public interest work and so forth represented on the bench, like Ketanji Brown Jackson. But I also, just to say, it's not enough. And this is why this is so important, because I wrote a report for the Brennan Center with a co-author where we examined what it would take. And no matter how many new judges that Biden nominates in the current framework, he's nowhere going to come to bringing our court system to parity. It can't happen because very many of the retirements that are coming up are people of color and women, right? So there's a cohort. You have to remember that you're filling a vacancy. It's not always an old white guy. It's oftentimes it's an older person of color, woman who, may be a great judge. And so Biden's got to refill those seats as well. So that really is a problem unless we do the court expansion for the lower courts. And historically hasn't happened since the major court expansion since the Carter presidency. And our population has grown enormously. So it's actually something that is important to do, but it has this aspect that is absolutely critical, which is to make sure that our courts really reflect who we are as a people. And that's not a bunch of old white guys, right? That's people from all different backgrounds and people of color and more women. And if we don't expand the lower courts as well as the, I'm so sorry for my little tirade, but I think it's a really important point. And we don't necessarily talk a lot about it. But I do, we didn't have that perspective on the Supreme Court Commission. I know that was a leading question on your part. We were a bunch of stodgy law professors mostly. And so there was certainly some racial and gender diversity, not as much as there could have been, but there wasn't a lot of diversity in terms of our backgrounds, although I'm only recently come to the law professor world. But we really were kind of a tame bunch.
Yeah, I would say we were pretty tame. I mean, I think we had some relatively progressive members of the group, and we had a lot of witnesses testify, and we heard progressive voices there. I think ultimately the product of the Court Commission was very tame because we were giving both sides on all of these issues, and it didn't come out with as clear a statement of some of the things that I think are important as I wish we had come out with. So, to take one sort of obvious example, people are concerned that if Democrats expand the court, Republicans will do it in retaliation. And, if we break this norm, then they're going to do it too. And that, to me, ignores the very obvious fact that they already did it, right? You say you're not going to let Obama fill the seat that Merrick Garland was nominated for. You take the court down to 8. That's an 8-person court. Then you put in the Trump nominee. That's a 9-person court. So the court went down. It went back up, right? They expanded the court. And they did it not with a bill that was passed by both houses of Congress and signed by the president, which is the way that our democracy normally works. They did it through the unilateral actions of the Senate with people who represent less than half of the American people. So that, again, is like the minority taking over. And it's not like the minority being protected from oppression by the majority. It's the minority getting its will and making policy and deciding what happens. And we are not supposed to be a country that's ruled by a minority.
Can I chime in really quickly to that point? Because it's an important one in terms of concentrating power, which the conservative AstroTurf movement, let me be clear about that, it's an AstroTurf movement, not a grassroots movement, has done. And that's not unique. This Merrick Garland wasn't unique. That's been part of the playbook. And it's a playbook developed by judges, Article 3 judges themselves. One quick example is Judge J. Harvey Wilkinson on the United States Court of Appeals for the Fourth Circuit. So Virginia's a state that sits in the Fourth Circuit. In the 90s, it was the only court that wasn't integrated. So while he was chief judge, Harvey Wilkinson, he sent testimony and he testified in front of Congress, the Senate Judiciary in particular, saying there was 2 empty seats. We don't need any more judges. We're good. We are good. The names that President Clinton at the time were talking about appointing in the state of North Carolina were black judges. Black judges. And you have a white sitting judge sending letters to the Senate saying, we don't need any more. And that is important for a lot of reasons. One is because Chris writes about this. Blue slips that gave segregationist senators the ability to blue slip any black person that Clinton would have nominated, and they threatened as such. Jesse Helms. We don't need another judge because Harvey Wilkinson said we don't need another judge. While simultaneously in his opinions, at the same time, this is Harvey Wilkinson, he's writing denying relief to black and brown people in many cases, saying we can't give you that relief because of the judicial economy. You will overwhelm the court when there's 2 empty seats. Think about the hypocrisy.
Do you two want to respond to any of that?
Well, I could say the stories are legion, and we're all going to name check Chris now because but when I debated Carrie Severino, okay, now you're.
I'm so sorry.
At the Judicial Crisis Network on the NewsHour or something, and this was when President Obama had nominated 3 fine people to the D.C. Circuit, And all of a sudden it was court packing. And I said, well, it's really interesting that you call it court packing, because last time I checked, there were seats that had been created and they're empty, right? And Senator Grassley did the same thing. It's like, we don't need any more judges on the DC circuit until, of course, it's a Republican president. But, they absolutely have no problems with hypocrisy, and held out that somehow, it was illegitimate for President Obama to even nominate anyone to the DC circuit. And obviously, that is when Harry Reid, the majority leader of the Senate, had to work to get rid of the filibuster for lower court judges, because otherwise President Obama would have gotten nobody through. Nobody at all. So speaking to both of your points about how court reduction has actually happened very overtly without actually passing legislation because of the obstructive tactics of the Republicans in the Senate.
I want to get to the cases in a second, but first I just wanted to check if there were any other court reforms that you think are worth discussing here today, aside from Supreme Court expansion, lower court expansion. Talk a little bit about the idea of a congressional package of ethics reforms, some of the ideas floating around Congress for jurisdiction stripping. Kermit, I'm especially interested, you mentioned that earlier. Do you think those are worth pursuing, or do you think they would be obviated if Congress just went ahead and added 4 seats?
Well, so if you have ethics guidelines, maybe you can try to make the justices act better. And, there are things that the justices are doing now that I think are very disturbing. I think Clarence Thomas is the most striking example. But yeah, that's terrible. Would ethics guidelines help? Maybe. Are they enforceable? I think it's hard to tell. I mean, it seems to me like the simplest thing is to get different justices. I mean, more justices. So I think court packing solves a lot of problems. Jurisdiction stripping, I'm not that enthusiastic about. I think, again, like it's sort of constitutionally hard to figure out what Congress can do and how will it work, and are we just going to leave things to the state courts or the lower federal courts? The thing that I am really enthusiastic about as just a nonpartisan good government reform measure is term limits, because I think it's clear the appointment process is not working. It's not working because we don't have a predictable connection to the outcome of national elections. So how many appointments a president gets is like chance, strategic retirements, partisan hardball. That's not what should be determining the composition of the Supreme Court. If you do term limits so that each president gets 2 appointments per 4-year term, you make it rational. Pretty much everyone agrees that's an improvement. So I do want to plug that. And, that's what I went into the Biden commission thinking, hey, yeah, we're going to fix the system like this. Then I realized democracy is under attack. The Supreme Court is really part of the problem. We need a more drastic remedy. But term limits are still a good idea.
I mean, I hear you on term limits, but at the same time, I have to say, recently, the Washington Post editorial board came out with a piece saying, listen up, everybody. This whole court expansion idea, it's not only crazy and radical, but it's unnecessary, because we have a much better, mild-mannered, polite solution that everyone can get behind that will fix all of the problems you see today, and that's term limits. And everybody who's out there cheering on court expansion, they should just shut their mouths and get on board with the kinder, gentler, politer version of reform, which is term limits. And what's clearly going on here is that these folks they're begging for continued mainstream acceptance while trying to signal their discontent with the court and putting forth a reform that, in my view, would not have any immediate impact and would not tilt the court back toward any kind of mainstream position. And so I guess I'm interested if any of you are concerned that this idea of term limits is coming into the conversation as a diversion, almost a red herring, that moderates are using to change the conversation about court reform and zero in on this one narrower legislative fix that seems, in my view, very unlikely to happen.
I don't know that I see it that way. I don't think anybody's fooled by that. I mean, maybe I'm wrong, but I think it's obvious that, they just address 2 very different issues for me. I mean, I think one addresses long-term structural governance issues, that we're crazy in that we're one of the only countries in the world that doesn't impose some level of term limits on its certainly on its apex court, on its highest court. And all of our states except Rhode Island have term limits for their Supreme Court.
And Rhode Island doesn't count as a state anyway.
I bet there may be people from Rhode Island who disagree with that. Okay, yeah, don't tell Sheldon. But so seriously, it's crazy that people can serve for 35 years and have the massive power of judicial review that they have in our system. So it's a good governance reform. But if you're worried about democracy in the moment, it doesn't have anything to do with it. It really doesn't speak to that at all. So I guess I could see perhaps it being used. I think the Post is, well, it seems so typical. That I didn't even, pay much attention to it. But, I just remember during, I think it was when President Bush had nominated a bunch of super right-wing, this dates me, right? I worked for Senator Daschle in the Senate, and I was chief of staff to a senator. And during there were some really far-right nominees, and Democrats were holding some of them up. And the Washington Post editorial was, "Oh, enough of the politics of tit for tat." It's sort of, as if everything is just a procedural thing and nothing substantive actually really matters. So I think I kind of take it with a grain of salt. I think people know what this court is up to, and they saw the Dobbs decision. They know about voting rights, and I don't know. I think it's important that term limits was sort of something that was out there before court expansion was really back on the table. I don't see it really as, I don't know, maybe I'm wrong, maybe I'm naive.
I'll be happy to combat, term limits. I think your point's correct about democracy in a moment. Does that solve that? The other part of this is the political aspect around it with term limits. You would have to literally adopt the proposal that Eric Holder presented today. And the proposal essentially being at its core that within 60 days, the Senate would have to react based on a nomination. Because if you don't have some, that backdrop, conservatives have done brilliant shrinking the court. They're brilliant at that. And that's exactly what they will do. So every nominee that a Democrat would put forward, they are essentially going to shrink it. And they could do it in many different ways. So you would have to design, in terms of term limit, an idea where there is actually teeth to it. And even so, I'm sorry, I'm up here as a black man. I have 2 brown-skinned girls, so shout out to Beyonce. If you haven't heard that song yet, you need to hear it, okay? I'm thinking about them. I'm thinking it's not lost on me that at least half the people in this room lost their constitutional right. And then a significant percentage looking out in the audience really have not truly been recognized as a citizen under this Constitution, and we're still fighting for our freedom. So I want stuff now. And I know I heard MLK III, I respect him greatly, say, the instant gratification. I want that. I want that.
One more big picture question before we get to cases. So look, you brought this up, Kermit. We've got Justice Clarence Thomas sitting on and voting in cases that directly implicate his wife's political work helping Donald Trump stage a coup in 2020. We've got egregious ethical violations left and right on the Supreme Court and on the lower courts. We have, Judge Eileen Cannon in Florida running interference for the president who appointed her for the first time in the history of the Republic, purporting to halt a criminal investigation by judicial fiat just to protect Donald Trump's reputation. A decision so outrageous that 2 Trump judges on the 11th Circuit had to reverse it. We've got judges like James Ho on the 5th Circuit and Lawrence Van Dyke on the 9th Circuit, essentially just shitposting, pardon my language, in their opinions, just writing what they would write if they were your crazy great-grandma on Facebook after far too much sangria. And my question for you, and I'm really serious about this, when we see the ethical violations, when we see the egregious and indefensible rulings, when we see this stuff, at what point do House Democrats start using the word impeachment and thinking about and talking about an impeachment investigation, a probe, putting these judges on notice that what they are doing is disgusting and unacceptable, and that kind of conduct does not count as good behavior under Article 3 of the Constitution?
I'll chime in yes to all of that, Mark. Yes, all right. I echo all of that. But I would also say this. That was predictable. These are ideologues. Like, they had the bona fides, right? And that's exactly who Trump said he was going to appoint. He did. It should surprise none of us, these decisions that are coming out of any of these courts. You literally had nominees go up and appear before the Senate and would not say Brown versus Board was good law. So it should shock none of us when these decisions come out, as egregious as they are. And I'm all for a process of, hey, putting people on notice, but they're just doing the job that their whole organization wanted them to do. That's what they're doing.
Caroline?
Well, I have to agree. And I also think, based on kind of where we are right now, I mean, I don't see the Democrats going there, because I don't think, where do you start, right? Who do you start with? And if you don't start with, with Kavanaugh, which has been, probably top of the list, how are they gonna generate a, kind of political momentum around something like that gets, a conviction in the Senate? I'd much rather see them focus on other things that are more achievable and focus on getting better judges and expanding the courts, which are actually going to have a real impact. Getting rid of one James Ho or one, what's her name? Cannon.
Eileen Cannon.
Is not going to fix our problem, right? Because there are legions of others. So much more helpful would be to dilute their power.
Kermit?
Yeah, I think I mostly agree with Caroline there. Adding judges is something that we know we can do. Removing judges, it's harder. Get a conviction in the Senate, very hard. If you've got something concrete and demonstrable, like perjury by Brett Kavanaugh during his confirmation hearings, which I think you have pretty easily, then maybe it's worth going after that just to sort of lay down a marker that this is not acceptable. But I don't think he could be removed. So I do think in terms of practical consequences, adding judges does more.
Thank you. Long-term goals. All right. Now let's turn to Merrill versus Milligan. This is, as I'm sure many people in this room know, an effort by the state of Alabama and other conservatives to essentially eradicate the Voting Rights Act's bar on racial gerrymandering. Who here would like to volunteer to talk about exactly what's going on in this case and what they think will happen when this case comes down?
Well, I'll just say a couple of words, which is, there are so many things to talk about. Right. How the court first basically undid the ruling of the lower court, right? In a shadow docket ruling that didn't meet any of the tests that they purport to follow for injunctive relief, for emergency appeals, for their whole doctrine around when to interfere in an election and when not to. Well, this was well before an election. They didn't need to react this way. So violations on every front. But right now, we're now that it's going to be before the court, we're on to the substantive part, which is basically to say that the lower courts found that the state of Alabama had districted, so surprisingly, in a way that really disadvantaged minority voters, who represent about 27% of the population, and based on the district, got 14% of representation. Basically, got them 1 out of the 7 seats, and they would have been should be entitled to at least 2. The lower court, with, again, 2 Trump appointees or 2 Republican appointees, said this actually violates the Voting Rights Act. It's pretty clear that it violates the Voting Rights Act. Well, the Supreme Court is now about to hear that case, and I think we're about to see that somehow, and I'm sorry, this was gets me so angry, but that somehow the Voting Rights Act wasn't adopted to address discrimination in voting, and therefore can't be used in any kind of a race-conscious way. Well, really? What was the Voting Rights Act all about if it wasn't about that specifically?
You don't have to apologize for your anger at the Supreme Court in this room, Caroline. I think we all understand. Kermit, did you have anything you wanted to add?
Yeah, so this is not super specific to the case, but here's how I think about this. In 1876, there were 90,000 Black voters registered in South Carolina. In 1900, there were fewer than 3,000. So we have seen this kind of pattern in our history before. If you look around, if you put it all together, it's pretty clear to me what's going on. So we've got Reconstruction. It lasts maybe 8 years. It gives us, for the first time in our history, some semblance of a functioning multiracial democracy. And then it gets taken away. And it gets taken away in part by white supremacist paramilitary terrorism, right? That's a lot of it.
Can't imagine that today.
Well, right. So, you've got the red shirts, then you've got the Proud Boys now. But it's also done in large part by the Supreme Court. The Supreme Court is helping. And what we're seeing now is basically the same kind of reaction to the second Reconstruction. So civil rights movement, Warren Court, it's conventional to call that the second Reconstruction. What follows the first Reconstruction, when whites take back power in the South, they called it redemption. That's a name that stuck because we often talk about this era through their perspective. And I think that we should understand the historical period we're in now, starting in about 1980 with the Reagan Revolution, as the second redemption. And taking away Black voting rights is a definite goal here. It's a huge part of what they're doing, and it's all about minority rule.
Yeah, no, that is the goal, right? If the insurrection happened and what the demand was to not count Black votes. That's what it was about, right? If you asked what the remedy would be, it wasn't like, hey, everyone go revote. It was like, no, let's not count Philadelphia because of the Black population, right? Let's not count Atlanta and Georgia, and those states therefore go to Trump. That's what the insurrection was about. It was about, again, taking the franchise away from Black people. And that's what this case is. And if you're like, well, what's a prediction? Chief Justice Roberts is going to write it. We're a colorblind society, can't have kind of these race conscious. That's what the opinion's going to be. It's going to be another, probably the last straw to break the voting rights back. And like, that's the outcome. Let me be very clear. This upcoming term, Mark, and I know we joked in a call before, but it is going to be a Halloween massacre. It is.
One point I want to add here, which I think is important, you brought up Chief Justice John Roberts. Chief Justice John Roberts' entire professional career has been about dismantling the Voting Rights Act. When he served in the Reagan Justice Department, he wrote memos arguing that the Voting Rights Act was unconstitutional, all of these different ways to destroy it. He authored Shelby County versus Holder. But when that three-judge panel struck down the Alabama map as an egregious racial gerrymander and ordered a redraw, and that decision was appealed up to the Supreme Court only halted it by a 5-4 vote. And Chief Justice John Roberts was among the dissenters with the liberals. And what he said essentially was, look, I am no fan of the Voting Rights Act, but if we are going to eviscerate it, we have to do it the right way. We have to put this case on the merits docket, hear arguments, reason it out, and issue an opinion if we're gonna do this and just totally yank Section 2 of the Voting Rights Act. And what I think is so shocking is that 5 justices disagreed with him. And 5 justices said, no, we are doing it now.
Sure.
Because why? Because they couldn't wait, because they don't like Black political power, because they knew that in doing so, they would deprive Democrats of 1 more seat in the House of Representatives in this upcoming election. We know that probably more than 10 seats this coming election will go to Republicans instead of Democrats because illegal maps, racial gerrymanders, and partisan gerrymanders were instituted over the objection of state constitutional amendments, lower court judges, right? And I just find it so bracing and frightening to think that in some of these cases, at least, the chief is the liberal. The author of Shelby County versus Holder is the liberal saying slow your roll, and Brett Kavanaugh is in the driver's seat with Amy Coney Barrett and Alito and Thomas and Gorsuch.
Can I just disagree with you one brief moment, which is to say, I think Chief Justice Roberts is just as radical and right wing. He's just a better publicist.
I agree with that. He wanted to do it the right way because he thought that would preserve the court's institutional prestige to a greater degree, right? He thought people will not react as poorly to this if it comes down at 10 a.m. on June on a Monday like it's supposed to, rather than midnight in February randomly. And that's the kind of calculus we get from our more moderate justice now, not what's good for democracy. So speaking of things that are bad for democracy, let's turn to Moore v. Harper and the independent state legislature theory. We have a Halloween massacre on the table now. Who wants to play Leatherface in this restaging and tell us about what this case is all about? Caroline, would you?
Okay, well, so I never saw the movie, I guess. I don't like horror movies, but here I am, I guess, in one. Well, so this is this very, very crazy theory. This is, the right wing, they come up with these theories and everybody, I think the left, there was sort of law professor world kind of like, oh, don't take that seriously. It's so crazy. and then it becomes the law. So here we are. Broccoli. Anybody remember broccoli?
Yep.
So, yeah, that's what brought down the Affordable Care Act. So anyway, so this is an issue where the state of North Carolina, the Republican legislature adopted maps that were, guess what? Once again, really disadvantaged minority voters, or it was a partisan gerrymander.
It was really both. Actually.
It was both. Yeah, of course. I mean, let's do it all, right? Let's get the run the gamut here. So the state court, Supreme Court said that's unconstitutional under our state constitution. And then the question in this that's going to the Supreme Court is, who has the final word? Now, you would think, based on the way our laws normally work, is that, when a state legislature does something in violation of the state constitution, you defer to the state court's interpretation of its own constitution. Well, in this case, because in the federal constitution, in the elections clause, it refers to the role of the state legislatures in regulating elections. In this case, the state legislature gets the final word, according to the Republicans who are bringing this challenging in the decision. So if the Supreme Court agrees with them, this would mean that all other efforts to reform districting, so independent redistricting commissions, ballot initiatives that are passed by citizens, and state courts would be completely removed from the process of regulating state elections. That means like the really gerrymandered states where the Republicans dominate, maybe all the branches, legislature and the governorship. This takes the governor out as well. Can't veto a bad bill if if the state legislature thinks this is the way to regulate our elections. So it basically insulates state legislation to deny voting rights and has no backstop, except guess who? The U.S. Supreme Court. So we can count on Chief Justice Roberts again to save us.
Yeah, so I would just say quickly, thinking about this, like, what's the point? Why would anyone want to do this? Well, one is you do just strip away voting rights, because to the extent that the state constitution protects voting rights, now they don't bind the state legislature. But also, what's the benefit of transferring power to the state legislature? It's because they're gerrymandered. It's because particularly in swing states, Wisconsin, North Carolina, Pennsylvania, you've got a gerrymandered state legislature controlled by the Republicans, even though they're a minority of the voters. So again, like, this is something that could have a catastrophic effect because it's going to push those swing states to the right. It's going to push them towards the Republican column. And it's all about cementing minority rule.
And potentially overturning the results of the 2024 election.
Right. To say a little bit more about that.
No, if they have the power to decide, we don't have to abide by our state constitution, and the Supreme Court gets the last say. There was movements in 2020 with state legislators like, hey, can we essentially overcome the actual popular vote? Well, that, embracing this doctrine gives them the possibility to do just that, which is really, really scare all of us, especially as Kermit's point, in the swing states.
One thing I also find very interesting here, I alluded to it earlier, is that Justice Clarence Thomas is a big proponent of the independent state legislature theory, and in fact strived mightily to implement it during and after the 2020 election. And we now know that at the same time that Clarence Thomas was trying to implement the independent state legislature theory from the bench, his wife, Ginny Thomas, was lobbying state legislators in at least 3 swing states to implement it politically themselves by throwing out the actual results of the election and assigning their votes to Donald Trump in the Electoral College. So again, I didn't bring up the I word lightly, but when you see that kind of tag team between a Supreme Court justice and a political activist who are married, and you think, what would you think if you saw it happen in another country? I think it's pretty clear that we have a serious problem here. Last last case I want to discuss, and I'm so glad you brought this up on our call earlier, Brandon, because, you know, the election cases are critically important. The voting rights cases are critically important. But at the same time, the court is doing horrible stuff with criminal defendants and with habeas especially, right? So let's talk a little bit about Jones v. Hendricks in the time that we have left, and how that kind of gives us a window into the way that this Supreme Court is quite literally ensuring that people who are innocent remain behind bars and are even potentially executed.
Yeah, you just explained it perfectly, right? So this is the the Supreme Court, right? This is their attempt to resolve a circuit split. Essentially, the issue is, can incarcerated people have access to courts to say, hey, look, I'm actually innocent of this crime. And you actually said I was actually innocent of the crime. So it's really just about, do we have access to courts? Okay. And who started this circuit split? I know, Mark, you want to know, right? I know it's burning deep down inside. Well, I got the answer. Justice Gorsuch, when he was a judge, where he said, actually innocent people, you have no relief to the courts. I mean, the courts can't resolve this. So your relief, go to the president or somebody, but it's not going to be us. Now, that raises some serious habeas concerns, right? That my liberty, me being in prison in these cages, is being impacted because I can't go to the courts. So they're going to resolve this split. Look, it's predictable how they're going to come out. They're going to say, savings clause, sorry, it doesn't deal with these actual innocence claims. Your best relief is with the executive. Go to President Biden. Speaking of President Biden, needs to do more on this, right? Go to President Biden. That's who the only person you could get relief from. I mean, seriously, actually innocent of crimes, in that the government agrees they should have access to the courts. And yet the Supreme Court's like, hey, come on, we got to appoint an amicus who's going to say, keep these black and brown people in prisons. And that's exactly what they did. And it's exactly how they're going to rule in that case.
Kermit, tell us a little bit about how we got here and what happened last term in these sets of cases where the Supreme Court suddenly pivoted away from previous more centrist or progressive views on habeas toward this very carceral idea that actual innocence doesn't really matter.
Well, we've had hostility to habeas for a long time. We've had it more from the political branches. So the federal government and, of course, the state governments tend to not like habeas. But it's since the Supreme Court turned, really sharply conservative that we've seen the more kind of crazy ideas. I mean, the idea that actual innocence doesn't matter should be shocking, right? You're actually innocent. The government maybe even concedes this, but hey, we can't let you out of jail on that ground. It's this sort of willful ignorance of substantive justice, and this is sort of like John Roberts. I think if you can hide it in a procedural wrapper, he's happy to do it. And he wants to go to the same places that the other justices do. It's just that now the Supreme Court is sort of willing to do it in a more brutal and open way.
I would just add that as a journalist, it can be difficult to explain these cases because they often do come wrapped up in this procedural gobbledygook that's very difficult for most people to penetrate. And I think that the Supreme Court press corps frequently fails miserably to convey the real human stakes and the substantive injustices in these cases, and focuses far too much on the wordplay that the conservative majority uses to try to conceal what's going on. Caroline, was there anything you wanted to add here?
No, but I think it just reinforces why I think we need to really stop the journalistic coverage of Chief Justice Roberts as somehow as a moderate. I mean, he is a radical in sheep's clothing, is what he is. He is, I think, the most dangerous of them all.
And you know what I think he would like? 4 new colleagues to join him and show him the true way. Thank you so much for coming, everybody. Thank you to our panelists. Done a wonderful job. Thank you, Demand Justice.